Hi, everybody, and welcome to the new legislation impacting D&O liability for community associations webinar, part two. I'm Marketing Manager Sherry Branson for Kevin Davis Insurance, and I'm joined today by Kevin Davis, the president of Kevin Davis Insurance. Hi, Kevin.
Hey, Sherry, how you doing?
I'm doing great, thank you.
That's
And
good.
Kevin,
That's
we have
good.
a very, very special guest with us today. We have Dawn Bauman. Welcome, Dawn.
Hmm.
Hi, Sherry. Hi, Kevin. Thanks so much for having me.
Oh,
Sure.
thank you. Thank you for joining us today. And
Mm,
we're really excited to have Dawn today. Dawn is a CAI Senior Vice President of Government and Public Affairs and the Executive Director of the Foundation for Community Association Research. She's worked for CAI for more than 20 years at both the international and chapter levels. And now we're going to talk, we have, let's see, we're going to talk about our goals today, Kevin. What are our goals? Oh, I did want to
sure.
mention, let me take a quick second to mention, we're doing a Q&A at the end of the webinar. So if anybody has any questions, please type them in the chat box and we'll be doing the Q&A at the end.
Yeah. Well, this is we're doing something really interesting, something I've never done. Last month or a couple of months ago, we did our special webinar on changes, legislative changes impacting community associations. And we had a lot of questions. And so I decided to go to the expert. I called my friend Dawn, who I've known for over 20 years. You had to be involved more than 20 years, so I've known you more than 20 years.
I like
And
to
to
I like to keep it at 20. It still makes me feel young.
I never tell anybody how long I've been involved, but we talked about CAI. Sherry, you mentioned it twice, and CAI is the Community Associations Institute. So, Dawn, why don't we start by this? You telling us about who you are and your background with CAI. Let's start from that point.
Excellent. Hi, everybody. Thank you so much, Kevin. Thanks, Sherry. So my name is Dawn Bauman. I'm actually CAI's Chief Strategy Officer and Executive Director of the Foundation for Community Association Research. I've been around CAI since 1996. I started with the organization in Arizona as the chapter executive director of the Central Arizona chapter, and then moved to DC to run the Washington Metro chapter, which is CAI's largest chapter. And then I've been working with the headquarters office for since the year 2002. So I've had a lot of different jobs, including running our chapter relations department, running our CAM-ICB, which is our CMCA program, and running our government and public affairs department, which I still do, but I also have other responsibilities as well, including our international growth and development. So I've been around for a long time. I've had the just extraordinary privilege to work with people like you, Kevin, with stakeholders, professionals, subject matter experts, leaders in this industry here in the US and around the world. So one of the areas that I focus on is legislative affairs. So lobbying and organizing and working with our legislative committees at the state level and at the federal level. So I'm super excited about this opportunity because I'm passionate about this industry and I'm passionate about the good public policy issues for this industry and insurance. It's a big topic these days.
You know what? That's why I asked you. And again, I know your background, I know your excitement. And again, we have three areas we're really talking about. We're talking about legislative changes, the legislative challenges that we're facing right now, and the impact of insurance. The three items are going to be structural integrity issues, reserve study requirements, and consumer protections. And the reason why these are so important is because from a insurance point of view, whenever we make changes, they impact coverages one way or the other. On the D&O policy, it impact coverages because of three things. Number one, the lack of knowledge. There's people out there who don't know about structural integrity laws that are being passed. The number two is that, oh my God, I can't afford it. It's going to cost me money and we didn't budget for it. And the third thing is that, are there enough professionals out there to do the jobs that we want to know? So that's the kind of where we're starting from. Now, I guess what we're going to do is to start from the structural integrity issues there. Now, we know right now there's Florida has one, New Jersey. What's going on from your area when it comes to the structural integrity? And basically, the structural integrity has come about because of Surfside, because of the Surfside building went down. So let's start with that one. Why don't you give us a little background about what's happening on the structural issues there?
Sure. Of course, before the tragedy in Florida, the idea of structural integrity was not on everybody's mind. It was on everybody's mind from we want our building to be safe and it should be well maintained, but not with the sense of urgency that came following the tragedy in Miami, Florida. What people don't know is there are probably 12 local jurisdictions that have structural integrity requirements, which means that have building inspection requirements. Whether it's a facade inspection, most of them are, and that's where you just look at you have an engineer, architect, look at the building to see if there are any issues that need further exploration. So cities like New York, Boston, Chicago, Milwaukee, Columbus, Cleveland, Cincinnati, a couple of cities in New Jersey as well, and Philadelphia. So there are requirements for condominiums to have a facade inspection at certain timeframes. I'll tell you what, New York City has had the longest standing structural integrity requirement, physical inspection requirement, and it's probably the most strict. So currently the requirement in New York City is every building that is considered a high rise, so that's 5 stories or above, I believe, maybe 7 stories or above, must have every 5 years, must have a facade inspection of the building, of the parking garage, and of any balconies or terraces. And the association is obligated to get those inspections. It's just become part of the business. And think about it, there are a lot of buildings in New York. So the burden and the scariness of having those facade inspections, we should learn from New York that it is manageable and reasonable and actually results in better maintained and structurally sound buildings.
I'm glad you said that because we hear about what's happening in Florida right now in terms of SB 154, and everybody is panicking because they have to do this. However, what we found out is that they've had structural requirements also, for over 30 years,
Yeah.
and they've been doing it. Yeah.
Well, I will say, so Miami-Dade County, which had their 40-year certification requirement, which is basically a structural integrity of building inspection and a pretty invasive building inspection requirement, probably one of the strongest in the country. That's where the tragedy happened. And it was already in place. But listen, I understand legislators wanted to and want to address this issue proactively to make sure this never happens again. And that's why CAI developed our policy initiatives and model language for building inspection requirements, reserve studies, reserve funding, et cetera. So we've been working across the country in trying to help provide legislators with the resources, language, information they need to pass laws that are going to be reasonable and practical. And one of the things about the reasonability and practicality of this legislation and these laws is to make sure that it happens over a period of time that gives the associations the opportunity to save the money and to use the money for these building inspections if necessary, to have the appropriate building inspection, and to make sure, like you said up front, that we have the professionals to be able to provide those building inspections. Time is key.
This is great because you're answering the 3 questions that I have. In number 1, because of CAI, you're providing the education, the knowledge out there so that the individuals there don't have to panic. And then 2, you're having the professionals out there saying, we're ready to do these things here. And along with the education, you're teaching them how to budget. So to me, and again, that's why I asked you, because I wanted to hear from you that CAI is, number 1, believes in the structural integrity issues that are out there, and they are really promoting that this is a great way to be. And you're saying it should be universal, should be throughout the country, that these structural integrity laws should exist. Is that?
Yes, but I want to be clear that the answer is yes, and we absolutely support legislation and statutes. We want to give board members the backing and authority they need to be able to do those inspections and not have to go to a community vote where some owners might say, I don't feel like spending my money on that. Well, unfortunately, some owners don't recognize the critical need of having an inspection to making sure that any concerning issues are addressed. But also very important, it's so important to make sure that the devil's in the details and that the details are addressed in the legislation to make sure that it isn't rushed, isn't being the requirements are not rushed, and that it allows for associations to have the time to be able to get those inspections, save to get those inspections, and then make the repairs that are needed in a time frame that's reasonable. Also, not every building needs a building inspection. Only buildings that are older than 20 years old need to have their first facade inspection. Buildings that are 3 and 4 stories probably don't need to have regular building inspections as aggressively as the other buildings. So the mandate from a best practice, let's get everybody having building inspections. But from a legislative mandate and a statutory mandate, let's make sure that we're targeting those buildings that need to have the support of the law so that boards can do what they need to do.
Perfect. So one more thing about structural integrity. What keeps you up at night? What's that thing that worries you about these new laws that being in effect?
I think that the one size fits all nature of legislation. Like I said, 3 and 4 story buildings, buildings that are 20 years old, 25 years old. So if a building is super well maintained, if a building isn't well maintained, those time, that 20 years, that 15, 20, 25 years, it's going to vary. So the one size fits all. In legislation, CAI tends to support legislation that is the lowest best initiative. So not the highest standard. So I'll give you an example. So for like manager licensing, we don't think you should require a PCAM. You should require a CMCA, that entry level certification. The same with building inspections. You shouldn't go out there and require an invasive building inspection of every single building in the US. No, we have to create some criteria, and that top end is where we should start, where the highest need for these issues, that's what should be statutory mandated. So that one size fits all keeps me up at night, because it's going to cost some associations more than necessary because of the one size fits all nature of legislation.
That's a good point, because a 20-year building, every 20-year-old building is different. And that's a very good point there. Okay, so let's move on to reserve study requirements. And this is a tough one because, first of all, we agree that every association have a reserve study, at the minimum, a reserve study. But some states say you should have reserves. Some states you should have reserve study. Some say you should have a fully refunded reserves. What is the standard? I mean, CAI has a standard. Let's start with CAI's standard, and then we can kind of move on from there.
Okay, so we're talking legislation. I do
Yes.
want to make sure that what I share with your audience, that CAI differentiates between best practices and legislative mandates. Best practices are a much higher standard of requirement. A legislative or statutory requirement, again, should be a lower requirement. For reserve studies, from a statutory mandate, CAI supports state law that mandates reserve studies for all community associations that have common property valued at $10,000 or more. So every community association should have a reserve study if they have common property valued at $10,000 or more. How often that reserve study is updated? Our policy says we support state law that requires an update every 5 years. Our best practices do it every 3 years. But every 5 years, because there are some communities, they just have a retaining wall. They don't need to have an update every 3 years. So let's not put that into law. So that kind of captures that one size fits all situation. From a funding standpoint, because especially right now, for communities that don't have adequate funds in their reserve study or their reserve fund, if we're passing legislation that requires reserve studies, some of these communities, it's new to them, they don't have a reserve fund. To require and mandate funding could be financially problematic for community associations to comply with the law. So at this time, we do not support state law that mandates reserve funding of any level, except for the reserve funding as advised by the reserve professional. So we don't say it should be threshold funding, it should be fully funded, it should be partially funded, component funded, etc. The reserve fund should be funded in accordance with the recommendation of the reserve study professional. Best practice, you should be fully funded.
Mm-hmm.
But that's
now, what is fully funded means? Because again, you look at these things and they say these state laws should have fully funded. You should have they'll say you should be fully funded, but they don't even say you need a reserve study, right? Some states says just make it fully funded. Yeah.
I love that. But you know what? I kind of love that because then it's then you have to have a reserve study.
Oh, okay.
But
okay.
Listen, I am not a reserve study expert, but CAI has recently updated very current reserve study standards that go through the definitions of fully funded, threshold funding, et cetera, et cetera. So I would like to refer your audience to our reserve study standards that have those definitions and the recommended requirements for all of the what a consumer, what a board should expect in their reserve study. And how reserve study professionals should be conducting their reserve studies. So I can share that in the chat or share that afterwards, but I'd rather defer to that for the definition.
Good idea. You can put it in the chat or share it later on. So, but then from a state law point of view, do you see more states requiring reserve studies, or do most states require? Just give me some of your things you found out.
Yeah, so right now there are 13 states that require reserve studies, 12 states that require reserve funding. In 2024, 7 states had legislation to support reserve studies or reserve funding. Those are new states. And in the past, since 2021, we've added 5 states that have passed laws to require reserve studies and or funding. And those are proactive initiatives on CAI's part.
Okay.
And again, that's to support those boards so that the boards have the backing to say, we're getting a reserve study and we're funding reserves, and you can't, as an ownership, opt out of funding those reserves.
Yeah. And I think that is the big issue today, is the people who live there can say, we don't want to budget for reserves because guess what? I'm going to be moving in 2 or 3 years and it's a waste of corporate assets and you don't have the authority to pass a special assessment and blah, 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 blah.
Right.
Okay. So
we want to listen, I drive down my streets every day, and now I look at my neighbors and who has what level of maintenance of their home and in their yard. And everyone's different. Everybody has their own perception on how to spend their money, their own choice on how to spend their money as it relates to maintenance and care of their home. And that's what we see in these shared ownership situations as well. Everyone has their own opinion, and I appreciate that. Nonetheless, we have to act as a whole. Community associations have to act as a whole, and we have to act for the best of that building and the best of those homeowners living in that building, not for the maybe we'll put this maintenance off, because we have data and statistics out there that demonstrate if you defer maintenance, then the price that you're going to pay for maintenance on those issues that are deferred is likely to be 30% higher than you would have paid if you didn't defer the maintenance. So giving the boards the authority they need to not have to navigate everybody's different opinions on whether maintenance should be done or not it has to be a no-brainer because clearly it's become a life safety situation for
Mhm.
people living in these buildings.
Yeah. And I think that's the bottom line. It has as as simple as that, life safety. If you defer to maintenance too long, you end up what happened in Surfside. So you have to be able to do it. And the states are doing the right thing. And I love what you're saying, what CAI is doing by having a standard relative to the whole country. And eventually they will defer back to the CAI standard in order to run. So that's great. I like that.
Can I just make a comment on a statement
Sure.
that you just made? If you
Mhm.
don't do maintenance, you're going to end up in a situation like Champlain Tower South. I know you didn't mean it exactly like
Yep.
that, but
Mhm.
I do want to be clear that there are so many circumstances in that building that are different than almost every other building in the United States. Um, there are some buildings along the coastline that were built in the 1970s, like Champlain Tower South, under those types of building permit situation, using a developer that may have had shoddy workmanship and other circumstances, maintenance as a contributing factor. But there are so many other contributing factors. Buildings don't fall down. And I'm not saying forget about maintenance, but what I'm saying is this is certainly a reminder for us to focus on maintenance and everything we can do as an industry and everything we can do as building owners and managers to make sure this building is safe. But if you don't do maintenance, the
Mhm.
next step is not your building is going to fall
Yep.
because there were
Yep.
other factors involved. And
Mhm.
I think I know you know that, but I want to make sure that that's kind
Yeah.
of on the record.
That's important because as insurance professionals, we look at the worst case scenario all the time. That's all we see is, oh no, if we don't this thing done correctly, we see the end result. So we look that way. So glad you brought that up because again, it is about deferred maintenance because without deferred maintenance, your values will diminish. Your property values you have diminished people who don't care as much. So you do have to keep that up. And I think reserves. I love what you said about you can have you need a if you can have a fully funded reserve, but you need a reserve study to find out what fully funded reserve means. So even though you don't say you have to have a reserve study, you have to have it anyway. So I love that. I love that. Okay, now let's go on to the topic that most people want to talk about, and that is the Corporate Transparency Act and as it relates to community associations. So give us an update. What's happening? I know you let CAI has filed lawsuit. I tell you what, start from the beginning about what it is, how it impacts it, then we go from
Right.
there. Yeah.
All right.
Mhm.
Sure. And if you want to know what keeps me up at night, it is now the Corporate Transparency Act.
Okay.
So the Corporate Transparency Act is an act that was passed in 2021 under the Anti-Money Laundering Act. The purpose of the Corporate Transparency Act is to try to stop money laundering and use of funds for terrorist activity and illicit activities from using corporate shells to hide that money and to launder money for terrorist activity and illicit activities. So so this law passed in 2021. CAI didn't really know about it. Most businesses didn't really know about it. This law impacts most of the small businesses and small corporations, including nonprofit corporations in the US. There are 23 exemptions in the Corporate Transparency Act, and those exemptions are for bigger businesses, so businesses that have $5 million or more in annual income and 20 employees or more, and that are otherwise managed or regulated under other government agencies, including banks, insurance providers, and other highly regulated industries. Community associations, small nonprofits, have been stuck under the umbrella of the Corporate Transparency Act. Now, there's the one area, the larger association, $5 million in annual income and 20 employees. Also, 501c organizations. There are very few, but there are some community associations that are incorporated as a 501c4. They're exempt from the Corporate Transparency Act because the exemptions include 501c exemptions. Well, it has been determined by attorneys that the Corporate Transparency Act applies to community associations. And this was brought to our attention the middle of 2023. So we started a two-prong approach at that point to try to get community associations out from under this. First, we had a deep dive with our government affairs experts to determine whether this applied. The answer was yes. And should CAI try to get community associations out from it? The answer was 1,000% yes. There's no example of money laundering for terrorist activity or illicit activities. So 100% we should try to get community associations out from underneath the Corporate Transparency Act. So we started taking two approaches. One, a lobbying approach to members of Congress. And that we've been continuing, and I'll give a little bit of a report on that. The second approach was when the law passed, within the law, it had a procedure for requesting an exemption from the Department of Treasury to be exempt from these requirements. Department of Treasury has oversight of this law and the implementation of this law. So that was the second approach we took. And we started that approach in 2023. That approach is still outstanding. We continue to have conversations with the staff at the Department of Treasury. They have not told us no, that they won't give us an exemption, but they have implied that they're not going to give us an exemption because they put out guidance documents for homeowners associations and community associations for compliance. Once they found out that we're going to file a lawsuit, which is our third approach, they reached out to us and said, maybe we can have another conversation about this. And of course, we are very interested in continuing to have a conversation with the Department of Treasury to request an exemption. So that third now area of activity of CAI is the Board of Trustees, based on a recommendation from the College of Community Association Lawyers and our Government Public Affairs Committee, approved to file a lawsuit, hire an attorney or a group of attorneys to file a lawsuit against the US government, which we just filed September 10th. So those are the three areas that we're trying to get get community associations out from underneath this requirement. The requirement for community associations that existed before January 1st, 2024 is for them to file the beneficial ownership interest filing, and I'll talk a little bit about that in a second, by January 1st, 2025. So that's the deadline. That's the big looming deadline. And we have a lot of guidance on our webpage regarding what a beneficial owner is. A beneficial owner is typically going to be members of the board of directors of the community association, including the directors and executive committee. And the requirement is that those individuals have themselves filed into a database that is managed by the federal government, providing their name, address, passport information, driver's license information, and other additional information about who they are into that database. It's created a lot of concern for board members. We got a lot of pushback from board members saying, I'm not going to serve in this role if I have to put all of this information out there and then be subject to potentially criminal penalties and jail time if I don't put this information out there, or if I make a mistake on the information, or if I don't update my information within 30 days after something needs to be updated, maybe an email address, maybe an expiration date on a driver's license, etc. So penalties for not filing or for failure of complying is $500 a day up to $10,000 per individual, and jail time as well, which is just unreasonable for board members to put themselves to expose themselves to those types of penalties. So from the advocacy standpoint, right now, we have not been able to get an exemption for community associations. We're not stopping our work on it. We are working very diligently, and there are a lot of moving parts, and there's a lot of conversation, a lot of activity, a lot of awareness from members of Congress on this topic. However, as of today, September 19th, 2024, the community associations that don't qualify for an exemption must comply with this requirement by January 1st, 2025. We hope before then that we will be able to get community associations exempt, but we're just not sure. So from the advocacy standpoint, there is legislation out there that exempts community associations from this requirement. We are the only industry that has legislation out there with this exemption. The only industry. There are other bills out there that would delay implementation by another year. So instead of January 1st, 2025, it would be January 1st, 2026. There's legislation out there that would repeal the whole Corporate Transparency Act. It's a very bipartisan issue. So the Republicans are fine repealing or delaying the Corporate Transparency Act. Democrats are not. So since we have a Republican House, legislation has passed that would delay this for a year, passed the whole House. It was something like 420 members to 1. The Senate will not even entertain this legislation. The Senate's not going to entertain this legislation. It's not going to happen. There's also, again, we're the only industry that has this bill out there that would exempt us particularly. No other industry has that out there. So there is a lot of conversation among members of Congress. They're talking with members of the Department of Treasury, letting them know that it is possible that community associations shouldn't be wrapped up in these requirements. So we also have, let's look at the political landscape. We're in September, and we have an election in less than 2 months. So there are only a few short weeks of legislative activity available before the election for anything to pass. If I were to look at my crystal ball and my 8-ball, chances for any legislation passing before the election is pretty minimal. Chances for legislation passing after the election, remember, this is very partisan. We have a tight race in the Democrats holding the Senate. We have a tight race in the House holding the Republicans holding the House. No one is willing to extend themselves across the aisle on this issue. So nothing's going to happen, I don't think, before the election. After the election, we might see a little bit of break, and we might see some conversation with this coming back up. But then we have November to January, not a lot of time for the legislative session either. Not sure that we're going to see any sort of legislative change. We have the Department of Treasury that we've been working with. They may try to get us exempt, but there's quite a process for that to happen. They would have to comply with the administrative procedures rules, which would require posting a potential exemption for comment, a comment period, and a response period, and a comment back, which would take us past our deadline of January 1st, 2025. So even if that does happen, the best case scenario, it's not going to happen until after the deadline. The last is the courts. So we filed a lawsuit. We also filed a motion for a preliminary injunction. And that preliminary injunction said, hey, can you please, judge, just allow things to remain status quo so that we don't have to comply until the courts consider the merits of the case. So we have a hearing on October 11th for consideration of that preliminary injunction. We'll see what happens. We won't have a determination on October 11th, but my guess is we'll have a determination from the courts within a couple of weeks of that time point. Perhaps before the end of October, we'll know if we get a status quo. We don't have to comply until the end of the court case. That will be interesting to watch. And who knows what can happen with the court case. I don't know. Maybe we'll be able to continue negotiating with the Department of Treasury, with the attorneys, with the US government. Maybe this will move more quickly than other lawsuits on this topic area. We filed in the Eastern Circuit of Virginia, which is known to move quickly. It's one of the reasons that we filed in this particular circuit. So maybe it'll move quickly. I think we will have more news at the end of October. I don't know what that news is going to look like though. And I don't even, my 8-ball says, please ask again later, because I just don't have a response to that one. So that's where we are. I do want to tell everybody things move quickly and we update our website all the time on this topic. If you go to caionline.org/CTA, you'll get the most up-to-date information.
Wow, that was a lot.
It's a lot.
And not only is a lot, but we are saying that we know January the 1st, you got to start doing it. You open up the door a little bit so that we may not have to, but the door, I mean, it's not open that much, that's for sure. So,
that's right. That's right. And I think that management companies are suggesting to are recommending to their clients that they comply with this. And that is absolutely the responsible approach. We're doing the best we can, but we do urge community associations to be responsible and prepare for this deadline and be sure to be able to comply with this deadline, because we just don't know what's going to happen.
All right, thanks a lot. Listen, that was great. Sherry, come back if you have any questions out there, and let's see, but Dawn, you did an excellent job of going through these issues, and I hopefully that the people there, come on, share. Got any good questions out there? What
We did
people's
get
thoughts?
Kevin. Yes, thank you. That was great information, Dawn. Fantastic. We did get a few questions that came in, Kevin. And I did want to take a second before we go to the questions to mention a couple of things. Travelers insureds who have community association management liability have free access to a risk management helpline, which is available Monday through Friday. It's 1 hour of free risk management advice from a law firm. And this is a great resource, a great tool to share with your insureds. And I did also want to mention that Kevin Davis, along with Robert Nordland and Julie Adman, host a podcast called Common Sense for Common Areas. And Dawn was a recent guest on that podcast. You can find it on all the places that you find your podcasts: Apple, Google, Spotify, and Stitcher. So feel free to listen to that podcast. It's loaded with great information. And now we have time for a Q&A, and let's take a look at the questions here. Let's see. Here we go. Okay, we have one from Skylar Jewell. Thank you, Skylar. Thanks so much for sending in your questions. Skylar would like to know, for the large operating company exemptions, would self-managed associations meeting the 3 requirements, more than 20 full-time employees, 5 million in revenue, et cetera, be exempt from the CTA reporting requirements?
So I'm not an attorney. I want you to go to our website, but I believe the answer is yes. You have to meet all of the requirements, but I believe the answer is yes. So go to our website. We do have an FAQ on that, and you should be able to find your answer there. We've had our FAQs vetted by some attorneys.
Perfect. Okay, great. Thank you. Thank you, Dawn. And thank you, Skylar. And now we have a question from Prez Featherston. Thank you, Prez. Have any states weighed in on the CTA?
That's a great question. And the answer is not to my knowledge. We haven't had, from a legislative standpoint, not to my knowledge. From an advocacy standpoint, also not to my knowledge. If states have said, if governors have said, hey, stop doing this, not to my knowledge.
Okay, great. Fantastic. And Kimberly Wolf, thank you, Kimberly, for your question. She would like the CAI web address again, if you could repeat that.
Sure. It's www.caionline.org.
ORG. Okay, fantastic. Thank you. Thank you, Kimberly, and thank you, Dawn.
Oh, and one thing, Dawn, you should probably give out your email address if I want to contact you also. You can put it in the chat. Why don't you put it in the chat?
I'll put it in the chat, and I put a couple of other things. Oh, okay. Actually, I should have put it in the Q&A or in the chat.
I guess
I guess either one.
it's in the
Either
chat
one.
now. No, I see it's in the chat. You have
It only goes to the hosts and panelists.
Oh, okay. Um,
I'll do it in the
Q&A. That's a good question.
I'll do it in the Q&A.
Oh, I tell you what we'll do is we'll put a slide up. Troy, put a slide up with this in here. See if you can do that. Okay, go ahead. Let's see if you can do it.
Awesome.
Okay.
Great,
We
go
have
ahead.
one more question, by the way,
Okay. Mhm.
from Jeanette. Thank you, Jeanette, for sending in your question. What states have reserve study statutes?
All right. I did put in a link that hopefully will be shared on the slide. But let me tell you, Washington, Oregon, California, Nevada, Utah, Colorado, Minnesota, Florida, Tennessee, Ohio, New Jersey, and there are others. There is, if you'll go to the link, and it'll the link will give you our map, which shows every state that has a statutory requirement. And if you click on that map, it'll take you to the actual requirement. We also have a report that shows you almost every state, 35 or 33 states, have at least a disclosure requirement for reserves. So where the association has to disclose to the owners through the budget process if there are reserves. So we have a whole chart that says what the state is, and what the actual requirements are. So that'll be better than me just listing them off. It's a great resource.
I
Perfect.
just put it in the chat to everybody, so you have the information in there. So your email address, Corporate Transparency Act info, and reserve study. So that's good. Any other questions there, Sherry?
We have one more that came in. Do you have time for one more?
Sure. Yeah,
Okay.
Let's do it.
Great. Okay. How or will D&O respond to claims and issues over the CTA?
Wow, it's you know what? It's a great question. However, let me tell you what my thoughts are, and it's a great question. We think about it. The boards have a right. Boards have to do their job. So if the board fails to do their job, the D&O policy, they, the board has a duty, a fiduciary duty. So the law says you have to do these things. You have to do these things. If any violation of the law may violate. I mean, this is a complicated thing. I don't know. I don't even want to go there. I don't want to go there because basically what you're saying is if you're a board member and you refuse to do something that's the law says you have to do, is that kind of coverage. Insurance is not designed for that situation. It's designed for an error, an omission, a mistake, something that you just say, I refuse to obey the law. So I'm not saying it's not covered. It is covered. I don't know. And that's why I brought Dawn here to kind of give you it out. And again, the goal of the day was really to bring Dawn in to give a broader view of the things we've been talking about. We don't have an insurance answer to it, but we do have a practical answer, and that is to if the legislation said this is what you have to do, you have to do it. If you do it and you're sued, the likelihood of you being protected is greater than if you don't do it. So, and that's, I think, is the bottom line. So.
And at this point, it's still a law. And as Dawn said, we don't know what's going to happen before January 1st. So people have to proceed and follow the law.
You have to follow the law.
It might change after the first of the year, you don't know, or before, but in the meantime, you just have to follow it.
And even if we did defend it, you're still talking about penalties that's excluded under the contract. So if you have to pay $500 a penalty or $10,000 in penalty, whatever the penalty is, you don't pay penalties and if there's jail time, that's not covered either. So
yeah, that wouldn't be a good thing. No.
Yeah. So again, I think that the message here is that there are legislative changes here, and the best thing to do to protect your coverage is to conform, to have the knowledge that, and again, CAI has the knowledge, can help you with the knowledge, and it can help you move this thing forward without the minimum of stress. So, any more questions?
No, I think that's it. That's
Okay,
it.
any closing thoughts, Dawn?
I'm gonna actually leave a cliffhanger for the group.
Okay.
So we didn't talk about the fact that we might talk about this. But I'm gonna throw out there that Fannie Mae and Freddie Mac are having conversations about their insurance requirements
Yes.
for for condominium lending. The bureaucratic wheel moves very slowly, but we are having conversations with them. They're having conversations about challenges related to insurance requirements in condo lending for community associations. Nonetheless, they are not going to make buildings, projects eligible if they don't meet the insurance standards. So I do hope that everybody on this call is familiar with those standards. If not, shoot me an email and I'll send them to you. Familiar with those standards so that you're writing coverage or letting your clients know if that coverage isn't going to work for Fannie Freddie.
Wow. Okay. All right, put it in the chat before you go. Thanks a lot, Dawn. We appreciate it. And again, it's been great. And well, I guess I'll see you in January, I guess, for the law seminar.
I mean, if not sooner.
Yeah, I missed you a couple of days ago when I was in Washington, D.C.
I know. I thought you were going to be there on Tuesday as well. So I was like, all ready to see. And no, we finished up. I'm like, oh, man. So I'm sorry I missed you, but thanks for being here, or thanks for being with us and for everything that you do. And what a pleasure to be with you guys. Thank you for this opportunity. I really loved it.
All right. Thanks a lot.
Thank you, Dawn. Thank you,
Take care, everybody.
Did want to take a quick second. If you'd like to hear a recording of today's webinar, please visit our YouTube channel, which is youtube.com/kdisonline.com. You can listen to the recording of today's session again. And thank you, Dawn, and thanks for joining us. Take care.
My pleasure. Bye, everyone. Have a good one.
Bye-bye.
Thanks, Kevin.